Is Mr. Nwabo here?
They said that they stuck to his rules.
Okay.
So they don't have to show.
For the record, in the matter of 1505 East Oak Street versus Javon and Mary Robinson, file number 23-01914. May I have your appearance, counsel?
Good afternoon, Your Honor. Don Keskey, appearing on behalf of the plaintiff.
Okay, ma'am, what's your name?
I'm Mary Robinson.
Okay, let's see. You're when your son was in college.
Yeah, he's in college.
Okay,
Yes.
today was the date and the time set for a hearing on this matter. Did you all come to a resolution at all?
Yes, we have, Your Honor. The parties, including the plaintiff and Mary Robinson, have agreed to the entry of a conditional dismissal order. And the terms of that would be that she would pay, first of all, the total amount owed in rent is $6,007. Court cost of $7.88. A total of $6,194.88. She's agreed to pay $4,000 in rent and certified funds by this Friday. And then the balance of $2,194.88 by November 3rd. And then she would pay rent for November in the amount of $765 on November 17th, with the plaintiff waiving any late fees for November. And then she's agreed that the rent would increase on December 1 rather to $845. And she's agreed to allow me to sign the consent judgment on her behalf. However, we have the form and we can fill it in after the session momentarily and have it filed.
Oh, and she's
Yes.
present in person, so she can sign on her own behalf.
Yes, and then also as to the other defendant name, which is Javon Robinson, he is no longer living at the premises and the lease is expired. Right now, it's on a month-to-month basis. And so we would file a dismissal as to him because he's not going to be part of this agreement.
Okay, very good. And that's a complete and accurate understanding of the agreement, ma'am?
Yes.
So you're agreeing to pay the amount of $6,007 plus $187.88 in court costs for a total of $6,194.88. Yeah, that's accurate?
Yes, it is.
Okay, you're gonna pay $4,000 in rent by certified funds no later than this Friday.
Yes,
And the balance of that $6,194.88 will be paid by November 3rd, correct?
that is right.
And then your November rent will be paid on the 17th, and the plaintiff has agreed to waive any late fees, is that correct?
That is right.
And then you are agreeing or consenting to the understanding that the rent is going to increase in December to $845.
That is right.
Okay, and so you understand that you have the right to have a attorney represent you at today's hearing?
Yes, ma'am.
Okay, and you're waiving your right to be represented by an attorney?
Yes,
You have the right in this matter to proceed to a trial. You have the right to have your hearing today. Are you willing to waive your right to trial in order to enter into this conditional dismissal?
yes,
So the matter will be dismissed today based on the conditions that was stated here on the record. You have 3 business days from today's date. If once you leave here, you realize you misunderstood any of the rights that you just waived, you can return to the court within that time period and request to have this judgment or this dismissal set aside, you would then need to advise the court as to how it was you misunderstood your rights, okay?
Absolutely,
And partial performance does not satisfy this agreement. You understand that?
absolutely, Ms. Massey.
So you have to comply completely with that agreement in order to allow this to remain dismissed. If you default on any portion of this agreement, it could give the plaintiff the opportunity to file a motion to reinstate this case and immediately seek judgment. You understand that?
Absolutely.
Do you have any questions for the court?
I don't.
Okay,
Thank you.
no problem. Counsel, any additional matters for today's record?
Not on this case, Your Honor, and we'll fill in this form.
Very good.
Get it to you in a few minutes.
Thank you. You're off the record. Thank you.
Thank you.
Thank you. Okay, Brandon Sanders present.
Yes.
Where's Brandon Sanders? Thank you. Brandon Sanders? And Emily Neighbor?
Yes.
Okay, very good. And Cortez Landrum, that's you? Okay, on the record in the matter of Sanders Neighbor versus Landrum, file number 23-02096 LT. Appearance, or state your name for the record, sir.
Judge, my name is Brandon Lanier Sanders.
And state your name, ma'am. Emily Neighbor. And your name, sir? Okay, today was the date set for a hearing on an eviction here for non-payment of rent. I don't know if you all met in advance and came to a resolution at all, did you? Okay, so this is for non-payment of rent, correct?
Yes, Judge.
Okay, and how much are you indicating is past due and owing at this time?
Judge, we are seeking a total of $5,103.50.
$5,103
Yes, Judge.
50 cents for past due rent plus court costs.
Plus court costs and late fee and associated late fees.
What is the late fees
$50.
per month? How many months is he in arrears? So that $5,103 does not include the late fees, is that what you're saying?
It does include. late
It
fees.
does include it?
Yes.
Oh, okay, so $5,103.50 include the late fees, that's
It
correct?
includes the
Okay,
late-
so what is the court cost?
$58.50.
Okay, and that was for filing and service? Or
Yes.
did you say, okay,
And there's another component to that, Judge,
okay,
and that's the also $745 for trash code violation.
you can have a seat. And Mr. Landrum, you believe you have a lawful reason or defense as to why you don't owe them this money?
Yeah,
Okay, what is your lawful defense?
okay. So right here, I was sent that the lease would be terminated and I had to be out by November 30th. In an email,
November 30th of what year?
23.
This coming November?
Yes, ma'am.
What date did you get this letter?
August 10th. It was an email.
You received a demand for possession in this matter when? That would be the demand for possession is on a court form for non-payment of rent. My court record says you received that on July 8th. Is that accurate?
I would say yes, you know.
So you received it in July 8th. It says that
I have an email right here.
I don't want to know anything on the email at this time. I want to know, did you receive a demand for possession
Yes,
on July 8th? And it says that you owed a past due amount of rent. And July 8th, it was $1,150. Do you remember that? Did you get that?
yes, ma'am.
Okay, and so Do you still reside in the property?
No, ma'am.
When did you vacate?
August 9th.
You vacated when?
August.
August 9th?
August 9th.
And when you vacated, did you turn over the keys?
I haven't spoke with him. I still have.
Okay, so then you're not considered vacated if you didn't give them the keys and let them know you vacated. You removed all of your property? Okay, so they didn't have to pay to have trash removed when you left? You left the property in broom swept condition and did a walkthrough with them?
And have pictures.
You have pictures with you?
Yes, ma'am.
Let me see. Oh, they're on your phone.
Yes, ma'am.
I don't know why people think that I need to go into their personal phones to see evidence
I'm
when they come
sorry.
to
I
court.
didn't-
You don't have pictures of the evidence? Okay, and so when you received this notice to vacate that you saying that you owed $1,150, are you disputing that you owed that amount?
No, it was a conversation we had that I declined. It was 1,200, and I asked about the cutting I was doing on the other property, it's a duplex. And they tried to offer $50 and I declined
What is your rent monthly?
1,000.
Your rent is $1,000 a month?
Yes, ma'am.
Okay, and so you paid your June rent?
All but $100.
Okay, you paid your July rent?
None of it.
You didn't pay any of your July rent?
No, ma'am.
So the $1,150 would probably be the $100 that you owe plus the $1,000 plus a $50 late fee. Is that accurate?
It would have been 1,200.
Okay, but they say you owe $1,150.
That was good.
That's, so you just told me that you paid all of your June rent except for $100.
Yes, ma'am.
And then this was on July 8th, so you must have been late on your July rent. And that's when they served you with this, so it's another $1,000. And then there's a $50 late fee. So that adds up to $1,150, which is what they say you owed at the time that this was filed. Is that correct?
Yes, ma'am.
Okay, and then you claim that you vacated a month later, which means that rent would have accrued for another month,
Okay.
correct?
Yes, ma'am.
And you didn't pay that in August, did you? Oh, so that's a late fee that of another $50 minimum, right?
Yes, ma'am.
And you didn't pay the all but $100 in June. Why did you pay all but $100 in June?
Well, school had went out and my hours had shortened up, and my wife, she wasn't working due to school being out in the summer.
Okay, so they didn't assess it here, but technically they could have given you another $50 for that too, because you didn't pay it all up. But I see here, at least at this point, you're at 2,200. They're saying you owe 5,000 right now, and that's because you calculated until today's date. Is that accurate? Okay, and you said you moved out August 9th, but you never notified them. Why not?
Me and Miss Brandon was having confrontation, so I ended all communications. I tried to handle it with her, and I was referred back to him, so just trying to keep it all down.
What is confrontational about? I have moved out of your property and I want to do a walkthrough and turn over the key. What is confrontational about that?
Where me and his conversation was, I don't think we could have got that far.
Why not? Okay, you say you have pictures of how the property was left? The condition in which he left it?
Yes, Judge.
Okay, can you, first show him those exhibits that you have? And then I need to see them.
Yes, Judge.
My court officer is going to get them. No, he's gonna take care of it. You just give it to him.
The pictures are only in that one, so if he needs to see them.
He's just gonna look at them.
Yeah. The pictures
So
are there.
he knows what you're showing me.
See, that's not how.
Well, I didn't ask you that. I just want you to see,
Okay.
yeah, what they're showing me.
All right.
There are 7. Oh, that's for the judges.
I don't know what's in there, but I'll just take the pictures for now. Okay, so this first picture, and now is looks like there's a bed in here.
Yes, Judge.
Okay, so what date was this taken?
I was taken yesterday.
This is the condition of the property right now?
Yes, Judge.
Whose bed is this? Whose bed is this? Your bed is there now? They said they took this picture yesterday.
Not like that now.
Judge, we sent him a notification informing him that we was going to do an inspection of the property per the provisions of the contracts signed in 8 May 2023. We received no response. Once that deadline came, we went to the property, opened the door.
Yesterday?
Yes.
This picture was taken yesterday?
Yes, Judge.
And you're saying your bed wasn't there yesterday?
I went and got everything out.
Yesterday?
Yes, sir.
Judgment in favor of the plaintiff, $5,103.50. Now, what about the trash? You're saying to remove all that stuff off the property is what it was gonna cost you?
No, Judge, we didn't factor in the post cleaning.
That was a previous violation that.
Oh, do you have
the city had-
evidence?
Yeah, we have evidence of that. The
Yes.
city had assessed the fees for removing trash from outside the property that was filed. Yes.
Yes.
Okay, so that was, you did not file a money damages. It was just for possession, correct?
Correct.
Okay, so that's judgment in possession. It's a possession judgment for that amount. You would have to pursue money damages separately because you did not do that. Okay, and then Brandon Sanders and then Weaver. Okay, the address. This is a duplex?
Yes.
Okay, so what about this? It lets me know that this is his side of the duplex.
Well, at the time that those trash code violations were assessed, there was no one in the second unit.
Was
It was
vacant?
vacant.
How long was the other unit vacant?
It was vacant from May until June that we know. We acquired the property in May. And
You purchased this property in May?
yes,
Okay, and then you just had this tenant
yes, he was
Okay.
he was already in place. when we
already
purchased
there when
the
you moved in?
Yes.
You're shaking your head, that's not the truth?
Someone had just moved out right before they bought it. I did inform them when I turned the paper over to you guys that the city had came and got those 2 trash cans from outside that belonged to the upstairs.
You bought it in May of 2023?
Yes,
Okay, well, this says compliance, this is from before you purchased the property.
yeah, those are, but the fees were adding up already, and then the contractors came and picked up the trash when we already had the property, so they're assessed to us.
I recognize that, but if there was another tenant in there at this time then? In January of 2023?
So
February.
those are previous notices that they had built up to the trash actually piling up and then getting removed when we were.
I
Well,
recognize
we-
that, but what I'm trying to say is how is it attributable to him and not the other tenant who moved out?
Judge, we're not aware of any tenant that would never. So that's assuming.
I know you may not be aware of it, but you didn't own the property then, so how can we prove that this is his trash? Because this just says 1126 West Michigan Ave, and it doesn't say his particular unit, it's a duplex. And you didn't own it then, he claims there was someone else there and that they moved out. I don't have any other evidence, and it would be your burden to provide the evidence to support that, no, this is his. They didn't put a unit number on here.
Right.
And so that would have been on you to have to get to the city and tell them, we need a unit number.
Understand, Judge.
Because I can't pursue action against the person who's in unit 2 unless they tell you it was unit 2. This could have very well have been paper, plastic, and deteriorated furniture and outdoor furniture left by a previous tenant.
Understand, Judge.
So for that purpose, I have to deny this a portion of your claim, but judgment in possession for $5,161.50 is in your favor, and you can seek money damages separately if that's what you choose to do.
Yes, Judge.
Thank you. We can give them that back. And did you have any questions at this time, sir?
Yes, ma'am. I mean, I just, I just cleaned out everything. The house is clean, it's moving and ready.
Okay, so if you did all that yesterday, and that's why judgment was in possession, you originally told me you moved out in August, but until you get all your stuff out, you're still occupying people's property. And it's appropriate, you're a grown man, he's a grown man. There should be no reason why when we're handling business, you're getting so confrontational that you can't handle your business. Because in eviction, that affects your credit, that affects your livelihood, that affects you being able to put a roof over your family's head. So you should be able to control yourself for that purpose, if nothing else. And so you can't control his behavior, you can't control yours. And so for your own protection, you should want to do a walkthrough with them present, or a representative that they select to ensure that, hey, I'm moving your property the way it's supposed to be left so that you don't later get sued and you don't later get I don't know if you pay security deposit, but we have it withheld. So that's up to you to do. But as it relates to possession, you didn't hold possession of this property until yesterday. And so the judgment will be in favor for that. You're all set for today.
Okay. Okay.
And I'll deny your claim for the trash without prejudice because you just need more evidence. If that's what something from the city that says it was sent, that you can refile, okay?
Thank you, Judge.
Thank you. You're all set.
Thank you, Judge.
On the record in the matter of, is Mr. Woody here?
He just went home and Mr. Taylor.
Oh, okay, so we won't call that one. And then on the record in the matter of H Inc. versus Jody Pash and Christina Raymond, file number 23-02122. Council, may I have your appearance, please?
Hey, please, honorable court, Steve Gann, P 78219 for the plaintiff.
It's really low. I'm not sure why. We can't pick you up on the recorder.
I am sorry. Is this better?
That is a little better.
Let me switch headphones. Just one moment, Your Honor. Is this better, Your Honor?
Your Honor, is this better? Can you hear me?
That works. Yeah, yes, that's better. Thank you.
Thank
Can you repeat your appearance, please?
Yes, Steve Gand, appearing for the plaintiff for this honorable court.
Okay, thank you. And then counsel for the defendant.
Good afternoon, Your Honor. Veronica Pereira with Legal Services on behalf of the defendants.
Okay, and I see Christina Raymond is present, and I see Jody Pash is present, and then Ronald Raymond, all present via Zoom on separate devices. Today's the date that was set for hearing. I do have a conditional dismissal. It indicates that this case will be dismissed without prejudice upon the condition that the defendants move out of the premises and surrender possessions entirely on or before November 1st, 2023. Is that accurate, Ms. Raymond? You're muted. You stopped your audio, I think. Is there anyone for a copy of this?
Can you hear me? Sorry.
Yes, ma'am. Yes, ma'am. Okay, so is what I stated about how you're proceeding accurate?
Yes.
Okay, is that correct for you as well, Raymond, Ronald Raymond?
Yes.
Okay, Jody Pash, you are muted. Can you unmute, please?
There.
Okay, is what I stated about how you're gonna pursue, continue in this, is that accurate?
Yes.
Okay, and so you understand that you all have the right to have a trial in this matter?
Yes.
Yeah.
Okay. Are you each giving up your right to trial in order to enter into a conditional dismissal?
Yes.
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 Okay, and you understand that partial performance does not satisfy this, so that means you have to vacate on the date or before the date that you agreed to. And vacate means you gotta bring all your stuff out of the house and turn over that key. You understand that?
Yes.
Yes.
Okay, you have 3 business days from today's date. If once you leave here, you realize that you misunderstood the rights that you're waiving in order to enter into this agreement, you can return to the court and request to have this conditional dismissal set aside, and then you'll have to explain how it was that you misunderstood your rights, okay?
Yes.
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 Do you have any questions?
No, ma'am.
No, ma'am.
Any additional matters for the record, counsel?
No, ma'am. I think we're all set on this end.
Nothing for me, Your Honor.
Thank you, you're all set.
All right, thank you.
Thank you.
Thank
No
you.
problem. Thank you.
Thank you.
Thank you. Mr. Keski, did you meet with Renee Gill already?
No,
We do.
Okay, Renee Gill is on the Zoom. Do you have a device or do you need to borrow our iPad to get on Zoom?
I just need to, yes, we get.
Are they still there? They're
Okay,
done.
we have
They're done.
a iPad we can
Hey, no.
get for you to use.
It don't say it, just says sign in.
I'll help you, Ms. Pash, don't worry.
Bad. Video.
We,
This is
Mr.
leave.
Keski. Renee Gill?
Yes.
Yes.
Okay, hang tight. We're gonna get you in a private meeting room with the attorney for the plaintiff, okay?
All righty.
Mr. Wilson of RPM also.
Over
He's
here,
not
it's
on
just
Zoom.
all blurred.
Oh, he's gonna be in the room with you? Okay, that's fine.
Actually said he was gonna be on Zoom.
Oh, Your client said that he can get on Zoom from his phone, so is he gonna log in separately? Oh, okay, he might be in the conference room, so we can take you in there with him. Okay, I see Johnson. Sarah Johnson. Sarah Johnson, I think your matter was reset.
Okay,
I think, did you and Mr. Nawabu talk about getting more time?
I know he said something about rescheduling, but I didn't know he
Yes.
never got it, contacted me.
Yep, he submitted a request to reschedule to the court. Did we set a date already?
December 6th at 1:30.
It'll be December 6th at 1:30.
Okay, thank you.
Thank you.
Bye.
Let's see. Okay, Alexander Ray is here. Alexander Ray is present. Let's see. I just saw something paper. Oh, Michael Zapan.
Good afternoon, Your Honor. Mike Zappin, P68107 on behalf of the plaintiff.
Good afternoon. Did you meet with Alexander Ray already?
I have not.
Okay, and Alexander, do you have an attorney?
I do not.
Okay, so I'll put you in a private meeting room with the plaintiff's attorney so that you can see if you all can work out this matter, okay?
Thank you, Your Honor.
Let's see, is Juanita Edwards here? No, not yet. No, there she is. Oh, there she is. Okay, what about LaShawn Love? Where's Mr. Whitty? Ma'am, what's your name? Woodside Meadows. Okay, you're with Woodside Meadows. And then I don't think Mr. Whitty came back in here. Okay, back on the record in the matter. Sanders and Neighbor versus Landrum. Okay, my understanding is that the trash was included in this total of $5,103.
Yes, Judge.
Okay.
We just want to be honest.
Well, that's important. 50103 minus, it was 745. Okay, so his past due rent would amount to 4,358. 58, what was the change?
50 cents.
50 cents plus $58 in court costs.
Well, that amount, 4,358.50, that includes the court fees.
What was the court
The
fees?
court fee was 58.
We have 83.26 for court fees.
Oh, I must have missed it.
Okay, so now I need you to break down this rent then, because now our math is not mapping.
Okay. So it's 100 for June rent, 1,000 for July plus $50 late fee, 1,000 for August.
plus 50 for July, same for August.
Yep, same for September, same for October.
$4,300 that we have.
Yes, sir.
Plus 83.26. is the judgment. So $4,383.26.
Yes.
For a possession judgment, okay? Okay. And we'll get documents prepared to reflect that.
Thank you.
Thank you. Off the record. Okay, did Miss Edwards start her audio? Okay, she did. Juanita Edwards?
All right.
I'll be right back.
Juanita Edwards,
Yes, ma'am.
can you start your video, please?
Yes, ma'am.
Okay. Darwood, we gotta log in to meet with her. Do you want to log in to meet with Ms. Edwards?
Yeah, so just log into Zoom.
Yep, if you log into Zoom, you can meet with her and see if you guys can resolve it.
Should I step outside and do it?
Yes, please.
Empowered, explaining. He used to call the clerk's office and said he's in Grand Rapids without a working car. Can you hear you?
Okay. I don't know if I'm getting this right or not.
Is that Mr. Darwick?
Yes, I'm here.
Okay, I'm gonna put you both in a private meeting room.
Okay, thank you.
Juanita Edwards and.
All right.
Okay, let me bring someone back. Let's see. Okay, Mr. Sapon and, or Mr. Zappin and Mr. Ray ready to proceed.
Thank you, Your Honor. Mike Zappin, P68107 on behalf of the plaintiff. I did have a chance to meet with defendant, Mr. Ray. He's presented some issues that I was unaware of in terms of habitability. I don't know if I have a representative here from Sycamore Homes. Is there anyone here?
Yes, present in the courtroom.
Okay. Is there a way that we could get in a Zoom with Mr. Ray, someone from Woodside Meadows and myself to discuss those issues and see if we can come to resolution?
Do you have a phone with you, ma'am? Yep, we'll get her on Zoom and add her to your breakout room.
Thank you, Your Honor. Mr. Ray, we'll go back to that breakout room.
Okay, let's see. Okay, I see Mr. Ray is present. On the record in the matter of Woodbridge Commons versus Shanice Ash, file number is 23-01548 LT. Council appearance.
Jeffrey Ray on behalf of the plaintiff, Your Honor.
And Veronica Pereira of Legal Services on behalf of Ms. Ash, who is also present in the Zoom.
Thank you. Ms. Ash, today was the date set for a hearing, but I do have a conditional dismissal here. It states that the plaintiff is willing to dismiss the case today upon the condition that you pay the amount of past due rent of $4,798 due through the time period ending of October 31st, 2023. Further conditions state that Avon House Ministries has already provided a promissory note as of October 17th for the amount of $4,252 and will provide payment according to said promissory note, and that your remaining portion of $546 shall be paid by October 30th, 2023. And the plaintiff will return the required paperwork to Avon House Ministries within 5 days. Is that how you understand how you're going to proceed, Ms. Ash?
Yes, I do.
Okay, and so you understand, Ms. Ash, that you did have the right to have a trial in this matter?
Yes.
Okay, you want to waive your jury trial in order to proceed with this conditional dismissal?
Yes.
Anybody threatening you to get you to waive your right to trial?
No.
Okay, and you understand that partial performance does not satisfy this agreement. You need to perform in full. So that means even making sure that Avon House Ministries have paid their portion and that you paid your portion needs to be done on the dates that you say that they were going to be done. You understand that?
Yes, I do.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood your rights that you waived, you can return to the court. You can request to have this agreement set aside, and then we'll set it for a hearing for you to tell me how it was that you misunderstood your rights, okay? She froze. Did you hear me, ma'am?
Yes, I did.
Okay, do you have any questions?
No, I don't.
Thank you. Any additional matters for the record, counsel?
None for me, Your Honor. Thank you.
No, Your Honor, thank you.
Thank you. You're all set, ma'am.
Thank you.
You're welcome. On the record, in the matter of Eagle Manor Estates versus Renee Gill, file number 23-02124 LT. Council appearance for the record.
Good afternoon, Your Honor. Don Keskey on behalf of the plaintiff. Also
Fucking trying to have court.
of Renaissance property. agent for the owner.
Okay, today's the date and the time that's set for hearing. And you've met privately with Mr. Gill, who's present via Zoom. Did you all come to resolution at all?
Yes, Your Honor, during the breakout session, the parties have agreed that Mr. Gill would enter a consent judgment, Your Honor. The terms of the consent judgment would be that Mr. Gill agrees to owing rent of $5,410.46, court costs of $157.96, for a total of $5,568.42, and to pay that amount by within the 10-day period, which due to the weekend would be October 30th, 2023, although the defendant has agreed to move out and vacate the premises by October 27th, Your Honor. But we filled in that time frame along with October 30th on the consent judgment. We are not asking for a money judgment here. And also, I believe that the defendant has agreed that I can sign the consent judgment form for him, which I have done on the form, Your Honor.
Okay, Mr. Gill, is everything that Mr. Keski said accurate?
Yes.
Okay, so you want judgment to enter against you by consent, whereby you agree to pay the amount past due of $5,410.46 plus court costs of $157.96 for a total of $5,568.42, or vacate the property by October 30th, 2023. Is that accurate, sir?
Yes.
And you indicate that you plan to vacate no later than the 27th, correct?
Right. Yes.
Oh, okay. And you understand, sir, that you have the right to be represented by an attorney in this proceeding?
Yes.
You also understand that you had the right to have a jury trial. Is that correct?
Yes.
Do you want to give up your right to be represented and your right to jury trial in order to have this judgment entered against you by consent?
Yes.
Anybody threatening you to get you to give up those rights?
No, nobody's threatened me.
Okay, any promises being made to you in exchange for you giving up those rights?
No.
Okay, you have 3 business days from today's date. If once you leave here, you realize you actually misunderstood the rights that you just said you waived, you can request to have this judgment set aside and we'll set this matter for a hearing, okay?
Okay. All right.
Lastly, you did give Mr. Keski permission to sign this judgment on your behalf, is that correct?
Yes.
Okay, any additional matters for the record, counsel?
No, Your Honor.
Okay, you're all set, Mr. Gill.
All right.
Thank you.
Thank you very much.
Thank you.
Thank you. Thank you. What happened to Mr. Whitty?
He's still talking.
Are we ready to go back on the record, Mrs. Sapan?
We are.
Okay, back on the record in the matter involving Woodside and Alexander Ray. And you did meet privately. Were you able to come to resolution?
We were not, Your Honor.
Okay, and so Mr. Ray did present some issues as it relates to habitability. Is that correct?
He did during this conference, yes.
And this is an eviction for non-payment of rent. And how much, or when's the last time he paid rent?
I believe it was, let me look, Your Honor. I know the balances, but Looks like last time rent was paid was in April 3rd of 2023.
Okay, and then Mr. Ray, I recognize that you're indicating that there's an issue regarding the habitability. Are you saying that this issue has been ongoing since April 3rd?
It has been ongoing since our move-in date of April 1st.
Okay, so you moved in April 1st, 2023?
Correct.
Okay, you have evidence of these issues?
I do.
Okay, I have to set this for an in-person hearing. You need to bring your evidence, okay?
Would you like that printed off? Because it's mostly emails and photographs.
Correct. You need to bring physical evidence, so I'm not searching through anyone's cell phone.
Gotcha. Okay.
Okay, I'll give you a date. December 6th at 1:30.
Thank you, Your
Person at the court. No problem. Do you have any questions today, Mr. Ray? Mr. Ray, I didn't hear you. Do you have any
No,
questions
not
today?
as today, Your Honor. Not
Okay,
today, Your
counsel,
Honor.
Thank you. Counsel, any additional matters?
Not on this particular case, Your Honor. Thank you.
Okay, Mr. Ray, you're all set.
Thank you.
No problem. Have we seen LaShawn Love?
Yeah, she said, she was talking to Mr. Wisconsin.
Oh, okay. They just left, I guess. Okay, sounds good. I don't know where they are. Okay.
Right out.
On the record, in the matter of Todd Darwick versus Juanita Edwards, file number is 23-02140. Mr. Darwick is present in the courtroom, and then Ms. Edwards is present via Zoom. And you did meet privately. Did you come to resolution, Mr. Darwick?
I communicated by email just now with the admin house. And they are saying that they did mail a check to me. I don't have it yet. So I would ask that the case be adjourned for a couple weeks, and then hopefully I'll receive the money and I can dismiss the case.
Did they tell you the amount of their check? Okay, because there is a new court rule that does require us to state cases when they're getting assistance now, so. But we'll reset this for now, since it sounds like they've already issued a check. November 7th. November 7th at 2:45. Thank you. Did you get that date, Ms. Edwards? Oh, there's that. Well, she'll get it in the mail. Yes, it wasn't on there yet. You send an email right now. Yeah. We need Mr. Whitty. Yeah, it's been an hour. Devontae Wright, president? I don't see anybody on here. I'll wait for him to check on him. On the record, in the matter of Mary Avenue LDHA versus LaShawn Love, file number 23-01913 LT. Council, may I have your appearance?
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
And you are Miss LaShawn Love, ma'am?
Yes, I am.
Okay. Today was the date and the time set for hearing. Did you all resolve the matter?
Yes, Your Honor. We resolved the matter with a consent order for conditional dismissal, requiring that Ms. Love either pay or move by November 15th, 2023. The judgment reflects $75.49 in rent, $163.86 in costs, for a total of $77.1286. That's what Ms. Love would have to pay if she wanted to stay. I think the indication is that she's planning or hoping to move by that date. If she does move by that date, the case would of course remain dismissed. It is again, conditional dismissal signed by both parties, and I do have an order prepared for the court's consideration now.
And then Ms. Love, is what Mr. Visconti just said to the court accurate? Yes. Okay, so you are agreeing to have this matter dismissed today on the condition that you'll pay the past due amount of $7,549 plus court costs of $163.86 for a total amount due $7,712.86, or you'll vacate by November 15th, 2023. That's correct?
You said pay 700 of that?
7,000.
7,000.
You gotta pay full amount, $7,712.86, or vacate by November 15th, 2023. Okay, and you know you have the right to be represented by an attorney today? Okay, are you waiving your right to be represented by counsel?
I never been in this situation, so.
Well, you have the right to appear here and have an attorney represent you.
I'm just representing myself.
I recognize that, but I need you to on the record answer my question. Are you waiving your right to have an attorney represent you? Okay, and are you waiving your right to a jury trial on this matter? Okay, so you understand that partial performance will not satisfy this. So when I say partial performance, I mean you pay a portion of this and not the entire amount, thinking that that can satisfy, or you move out the property, but you leave all your stuff in there. And that's partial performance. You gotta either pay all of it or move all of your stuff out, and you gotta do it all before the November 15th deadline. You understand that? Okay, and so you have 3 business days from today's date. If once you leave here, you realize you've misunderstood the rights that you just waived, you can return to the court, explain how you misunderstood your rights, and then we can set this matter for a hearing, okay? Any questions for me? Any additional matters? You're all set. We'll get you a copy.
Thank you.
Thank you. On the record, in the matter of Thundercats LLC versus Helen Taylor and Felicia Langstaff, file number is 23-01992 LT.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff.
What's your name, ma'am?
Ellen Taylor.
Ellen Taylor is present. Where's Felicia Langstaff?
She is very sick. She has MRSA and she's very contagious. So she could not be here.
Today was the date set for a hearing. We're not hearing a hearing now because it took an hour to talk, so you guys have resolved this, correct?
Yes.
Okay. I have here a default as to Felicia Langstaff that will be granted for failure to appear. And then there's a consent order for conditional dismissal that you want to enter into?
Yes, ma'am.
Okay, so you are agreeing to have the matter dismissed by today under the condition that you will pay the amount of $1,800 due Owen for the period ending of October 31st, 2023. It says defendant shall surrender possession or vacate property before 10/31/2023. Defendant shall pay the balance in section 2 in monthly $200 installments to begin November 1st, 2023. That's accurate?
Yes.
Okay, so you understand that you have the right to be represented by an attorney?
Yeah.
And you're waiving your right to be represented by counsel?
Yeah.
Okay, you also have the right to proceed to a jury trial in this matter. I think you indicated here, or at least last week, that the property was pink tagged and you intended to file an answer and counterclaim. A, are you waiving your right to do that?
I did submit the counter. You was talking about the paperwork that you requested last time, right?
I see an answer here.
Yeah.
But you say you were gonna do a counterclaim. That means you were gonna sue or potentially sue the landlord.
That must have been a mistake.
Okay, sounds good.
Legal
So I-
services helped me fill out the paperwork.
Okay, sounds good. Okay, and so you understand that you had the right to be represented by an attorney, which legal services didn't represent you, but they did assist you. Is that correct?
They did.
Okay, and you're waiving your right to be represented by an attorney?
Yes.
And then you also have the right to proceed to jury trial. You're waiving your right to jury trial.
Yes.
Anybody threatening you into moving forward with this conditional dismissal?
No.
Any promises being made to you in exchange for you waiving those rights and entering into this conditional dismissal?
No.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you just waived, you can return to the court, explain how you misunderstood those rights, and we'll set this matter for a hearing, okay?
Okay.
Partial performance does not satisfy this conditional dismissal. So you need to perform in full. Otherwise, if you don't perform fully, completely and accurately as it's stated here on this paperwork, Mr. Whitney can then, on behalf of his client, file to have this case reinstated and judgment will enter against you immediately. Do you understand that? Is that a yes?
Yeah.
Okay. Any questions based on that?
No.
Any additional matters for the record?
Just so that the record's clear, this is an agreement that she's going to move out. It's not, even though it's a non-payment case, it's not a pay or stay situation. We're getting possession back, we're reducing the amount owed, and she's gonna pay that. Right, and we discussed that thoroughly.
I've already moved. I moved last month.
Okay, yeah, I see here, defendant shall surrender possession on order before the 31st. Defendant shall pay the balance in section 2, which is $1,800 monthly and $200 installments beginning the 1st of November. And you've already vacated and turned over the key?
I vacated, I have not turned over the keys.
Okay, you've gotten all of your personal items out of there?
Mine is, yes, my sister's is not.
Oh, okay, so that's that Langstaff, your sister,
Yes.
okay, okay, but it's it relates to you, you vacated, and so you're gonna turn over your key when?
As soon as she gets the rest of her stuff out.
Oh, you're gonna base it on when she gets her stuff out?
Yeah, because.
What if she never gets it out?
She'll get it.
Well, you don't know that, what if she doesn't?
Then I'll
You're
get
the
it
one
out.
with the conditional dismissal.
Then I'll make sure it gets out.
Okay, sounds good. That's your decision to make. Any additional matters for the record?
Nothing further, Your Honor.
You're all set.
I mean, the landlord already has keys, so I mean, I could give him the keys tomorrow if he wants them.
Well, until you tender over your keys, you still are occupying their property.
Okay. So yeah, I can set up a time to give him his set of keys tomorrow.
You're all set. Thank you.
Thank you.
Okay, thank you.
A couple of things. There was anybody in the hallway, because I don't see. Is it Zoe Perfett, Will Howard, Devontae Wright? Yeah, I don't think he's here though. That's the issue. Default judgment as to Devontae Wright can be issued. And then default judgment as to Perfett and Howard can be entered.
Thank you, Your Honor.
Thank you. You're all set, man.
Thank you.
Thank you.
Mr. Gower, did you hear that?
Yeah.
Okay.
No.
You can default. They didn't appear.
Okay.
Where did Mr. Woody go? Yeah, do you have one or do you need us to print you one?
I used my last one.
Okay, when Mr. Bigelow comes back, he can print you one. On the record, in the matter of 200 Block LLC versus Empower East Lansing, file number 23-01870 LT, council appearance.
Good afternoon, Your Honor. Norman Wade appearing on behalf of the plaintiff, the venue 2000 Block LLC.
Sir, state your name for the record, please.
Brian Daniels, I'm the owner of Empower Lansing LLC. I've retained a lawyer, Your Honor, but I don't believe she's made it down to file yet today.
What's your lawyer's name?
Gabriel Lawrence, Your Honor.
Okay, I thought you all entered an agreement.
We tried to do that first.
Yes.
And he did not have counsel. I've not heard anything from any counsel. This is going to be.
Gabriel Lawrence, you said is representing you?
Yes, Your
Well, if
Honor.
that was the case, why didn't she call Mr. Whitty so that you guys could sign an agreement by now?
Well, yeah, Your Honor, I just retained her. I was able to find somebody. No one will offer free legal services, so I had to find somebody that would do it for me, Your Honor. And as far as the agreement and the settlement, I'm still waiting on this guy who got in a car accident last week and is now in the hospital, and I'm waiting on him to be able to get caught up, Your Honor. I'm not trying to fight or prolong anything. I really am trying to get this done.
I'm not sure what any of that means, because I don't know what the terms, I don't know anything about this other than that it's in court for eviction today. Mr. Whitty?
Your Honor, the last time we were in court talking about an agreement, the balance was about 50 grand. There's currently rent to retain possession of $80,576.66. There have been multiple adjournments for defendant to obtain counsel. I'd like to request a court enter a default judgment at this time.
Your request for default judgment is granted. I've set this and reset this. August 9th, I reset it. September 13th, I reset it. September 27th, I reset it. It's now October 18th, and it's completely unreasonable for us to have to continue to hold over this matter for you to secure an attorney. If you have an LLC, you should know the law that is that you can't represent yourself in court as a corporation. You have to have an attorney, and Ms. Lawrence could have easily filed an appearance and made contact with the defense or the plaintiff's attorney without having to be here today to have this resolved, and that didn't happen. And so that being said, your default judgment is granted.
What does that mean, Your Honor?
That means that you failed to properly appear in court according to the court rules, so judgment is going to enter against you today.
Okay, how long do I have then? What does that look like, Your Honor? I don't.
There's a statutory time frame. This is for 25,000 for court money damages.
The money damages exceed the jurisdictional limit of the court, Your Honor.
Okay, sounds good. Okay, so we have a possession judgment in the amount of $80,576.66, plus court costs of $319.34 for a total possession amount of $80,896. You have to pay that or vacate no later than October 30th, 2023. There's a money judgment that's going to enter against Empower East Lansing in the amount of $25,000, which is the jurisdictional limit here, plus court costs $319 of 34 for a total of $25,319.34.
Okay, Your Honor.
Okay, any additional matters for the record, counsel?
Nothing from plaintiff, Your Honor.
Do you have any questions, Mr. Daniels?
No, Your Honor.
Okay, you're all set. Thank you.